Supreme Court dismissed the appeals in the matter of Delhi Development Authority versus S.G.G. Towers Private Limited. The appellant, Delhi Development Authority, formerly known as Delhi Improvement Trust, executed an agreement of lease. The lease agreement dated 17 July 1957 in respect of plot measuring 2044 square yards, situated in Industrial Area Scheme, Najafgarh Road, New Delhi, in favor of MS Mehta Constructions and Industrial Corporation Limited. On 25th November 1972, MS Mehta Constructions entered into agreement to sell with MS Pure Drinks Private Limited, second respondent. A register sale deed cum assignment dated 15 February 1985 was executed by MS Mehta Construction in favor of second respondent. In execution proceedings, Company Judge of Delhi High Court passed an order on 4th February 1985. Pursuant to this order, the Registrar of High Court lodged the sale deed for registration in Office of Sub-Registrar. When the second respondent went into liquidation and the plot was sold to first respondent in auction on 24 August 2000 in liquidation proceedings before Delhi High Court. The auction was held pursuant to notice of proclamation of sale issued by High Court of Punjab and Haryana on 9 June 2000. On 7 September 2000, first respondent applied for confirmation of sale made in the auction. Appellant appeared in the said proceedings and filed reply. Appellant contended that at no point of time had MS Mehta Construction acquired any interest in plot and therefore plot could not have been sold in auction. By 19th October 2001 order, learned single judge allowed the application filed by first respondent and confirmed auction sale. Aggrieved by said order, present appellant preferred appeal before division bench. By impugned judgment dated 21st January 2010, appeal was dismissed. When High Court was seized of liquidation proceedings and as there are other creditors of second respondent, court said it will not be appropriate to direct that a part of the amount paid towards consideration by first respondent should be appropriated towards unearned income payable to the appellant. Supreme Court said, we may note here that as far as auction conducted in liquidation proceedings of second respondent is concerned, the notice of proclamation itself records that the sale of the said plot was on as it is basis. Impugned judgment leaves the remedy of the appellant open to proceed against the concerned parties. These findings have been accepted by the first respondent. Court said we cannot direct the funds available in liquidation proceedings for payment of unearned income as large number of claims have been submitted. The scenario which emerges is that the first respondent is not entitled to either ownership or leasehold rights in respect of the said plot. The first respondent cannot claim to be a lessee as the lease in terms of lease agreement was never executed. At the same time, if according to case of appellant, MS Mehta Constructions had committed breach of lease agreement notwithstanding impugned orders, it will be always open for the appellant to adopt appropriate remedy for recovery of possession and recovery of unearned income against the first respondent. If the first respondent desires to get the transaction regularized, it is for the first respondent to apply to the appellant to accept unearned income or any other amount. If such a request is made, appellant will consider the same in accordance with the law.